My husband was buried on a Tuesday. At the reception afterward, in a church hall with paper cups and sandwiches nobody touched, my stepson handed me an envelope and asked me not to open it there. So I opened it in the car. It gave me 60 days to leave the house I had lived in for 26 years. And I want to be fair to my stepson before I take him apart, because the part everybody expects me to fight is the part that is true. His father did want him to have that house. I am not going to stand here and tell you otherwise. In 2016, he moved it into a family trust so that his 2 children from his first marriage would get it when he was gone, and he never hid that from me, and I never once asked him to change it. We had 26 years. His first wife had 22. There was room in that man for both of us, and I never needed the deed to prove it. So, the deed is real. It is signed, it is notarized, it was recorded on the 12th of April 2016, and I have never disputed a word of it. And every lawyer I spoke to in the first month told me the same thing, kindly and quickly, and for free. The house is not yours. The trust owns it. But 4 of them told me that without ever asking to see the trust. And the 5th one asked. Her name is Delia Ward, and she works out of 2 rooms above a dry cleaner. She took my case for a flat fee, and she told me later it was because of one thing she saw in the first 20 minutes. Here's the thing almost nobody outside a law office understands, and it is the whole of this story. Putting your house in a trust is not one document. It is 2 of them. The first document is the deed. A deed only does one job. It moves the title from one name to another name. That is all it does, and Raymond's deed did its job perfectly. The second document is the trust itself. And the trust is the thing that creates the name the house is moving into. Without it, that name is just words on a page. So Delia asked for the trust, and her request went out on the 9th of May, 2024, and then nothing came back for 6 weeks. 6 weeks is a long time to wait for a document that a family has supposedly been living under for 8 years. It arrived in the 3rd week of June, 31 pages. Beautifully drafted. Everything in it exactly as my stepson had always described it. Delia read it in front of me. She went slowly, and she did not say anything for a long time, and then she turned to the very last page and put her hand flat on the table. The signature page was blank, not smudged, not missing, not signed somewhere else and misfiled. Blank. No settler, no trustee, no witnesses, no notary, no date. Nobody had ever signed it. And I need you to understand why that is not a paperwork problem, because I thought it was one for about a day. There is a rule that is about 350 years old, and every state has a version of it. If you want to create a trust that holds land, it has to be in writing. And the writing has to be signed by the person creating it. Not intended, not discussed, not described to the family at Christmas. Signed, and the reason is not cruelty. It is that land outlives everybody who talks about it, and 40 years later the only witness left in the room is the paper. So if the trust was never signed, the trust never came into existence. And a deed that hands a house to something that does not exist does not hand it to anybody. The law has a name for what happens next. It is called a resulting trust, and it means exactly what it sounds like. The title goes back where it came from, which means on the 14th of March, 2024, that house was still Raymond's. And when a married man dies owning the house he lives in, the person who takes it is not his adult children. Now I have to tell you about the cottage, because this is where my stepson stopped being a son with an inheritance and became something with a legal name. There is a 1-bedroom cottage behind our house. Raymond built it out of a garage in 2004. And from June of 2016, my stepson rented it out and collected the rent himself. $1,800 a month from June 2016 until the month his father died. That is 8 years and 10 months. About $190,000 into his own account, and not 1 cent of it was ever reported to anybody as trust income. And when Delia asked him in writing for a single annual accounting from any of those 8 years, there was not one. Not a spreadsheet. Not a letter. Nothing. Which put him in a place he had not thought about at all, and it is the trap he walked into by himself. Because he had spent 8 years telling everyone he was the trustee. If that is true, he accepted the job. And a trustee who accepts the job owes every beneficiary an accounting, every year, whether anybody asks or not. And I was a beneficiary, under his own document, the one he had been waving at me since the funeral. Their lawyer is named Howard Boyd. He has been doing this work in that county for a long time, and he is not a bad lawyer. He is a lawyer who assumed nobody would ask for the second document. On the 2nd of October, 2024, he wrote Delia a letter explaining the blank page. And that letter is the reason I am sitting here in my own kitchen. He wrote that Mr. Kessler declined to execute the trust instrument at the time of the conveyance, but confirmed his intent orally to the trustee and to family members on multiple occasions thereafter. Read that again, the way Delia read it to me, one clause at a time. Declined to execute. He did not write that the page was lost. He did not write that it was signed and misplaced. He wrote that his own client's father declined, and that left them 2 roads, and there is no third one. If they argued the trust was real anyway, on the strength of what he said out loud, then it had a trustee, and that trustee accepted the office, and he owes me 8 years of accounting and every dollar of that cottage rent. And if they argued the trust was never real, then the deed handed the house to nobody, it came back to Raymond, and I take it as his wife. Every road ends in this kitchen, and their own attorney drew the map. His deposition was on the 4th of December 2024, in a room with bad blinds and a carafe of water nobody drank. And Delia asked him one question for the first 40 minutes, in about 9 different shapes. Are you the trustee? It sounds like a small question. It is the only question in the case. Because if he said yes, he accepted the office, and he owed me 8 years of accountings and every dollar out of that cottage. And if he said no, then the man who signed my 60-day notice to vacate had no authority over that house at all, and the notice was a piece of paper a stranger wrote. He said he was acting in the capacity of trustee. Delia asked what that meant. He said his father had asked him to handle things, and she asked him whether he had ever signed anything accepting that job, and there was a pause on that tape that runs 11 seconds, and I have listened to it more times than I will admit to. Then he said he did not think a signature was necessary. And that is the entire case, said out loud by the man bringing it. He did not think a signature was necessary. So what do you think a court does with a family that has spent 8 years administering a document nobody ever signed? On the 21st of January 2025, the drafting firm produced its own file. And I want to be honest about what I expected to find in it, which was nothing. I expected an oversight, a busy office, a page that got missed. The file had the drafts. It had the deed, and it had the firm's own calendar. The trust signing was scheduled 3 times: June of 2016, November of 2016, and February of 2017, and Raymond canceled every one of them. Not once. 3 times, over 9 months, he was invited into that office to finish the job, and 3 times he did not go. And in that file, there is a reminder letter the firm sent him in November of 2016. And along the left margin of it, in pencil, in my husband's handwriting, there are 6 words. Not until Adele is taken care of. He was not confused. He was not stalling. He had signed the deed in a lawyer's office with his son sitting next to him in April, and then he went home and thought about it, and he stopped. And he spent the next 8 years being asked when he was going to come in and finish it, and telling them he would get to it, and he never did. My stepdaughter Paula called me the week after the file came out. She said she had not known about the calendar. I believe her, because she is the only one who never asked me for anything. We settled in March. I kept the house. My stepson kept the cottage rents he had already spent, and I let him because I did not want the $190,000. I wanted the address. People keep telling me I won on a technicality, that my husband meant one thing, and a missing signature gave me another. But a man was driven to that office 3 times and turned around 3 times, and he wrote down why in pencil in a margin where nobody would look for 9 years. He didn't forget to sign it. He refused.